Welcome to the Hillsdale College Online Courses Podcast. I'm Jeremiah Regan.
And I'm Juan. We're back with our course, The American Left, From Liberalism to Despotism. We're going on to lecture number 8 today, Radicals March Through the Institutions. I think you'll notice a shift in the course, starting with this lecture. We've been talking a lot about different radical ideologies and the philosophies behind them and where they come from. And so it's been a little abstract.
Very important historical information, explanation of theories, but you're right. It is abstract. It's quite heavy.
And I think here, at least for me, is when the course starts connecting the dots and things start making more sense for me, and you start seeing the story unfolding and why we get to the point that we get to today.
Right. We've heard these ideas, these radical ideas. They encompass educational institutions, student groups, various factions within the left. But now we start seeing where they make a real difference in American life. And Dr. Slack gives us a nice outline. As the radicals march through the institutions, they co-opt Great Society programs, they co-opt education, they co-opt government agencies, and they change the way administrative law is understood. And Dr. Slack gives us a couple striking examples. And as far as co-opting the Great Society, he has an anecdote about a theater run by Leroy Jones, whose publicly stated purpose was to engage in the destruction of America. This is something that Great Society money was supporting. We look at something like admin law, and we see, as Dr. Slack puts it, how Congress surrenders its moral duty to judge on issues themselves and then to legislate on those issues for the good of the American people. And instead they defer to the administrative agencies, which are ostensibly run by scientists, but are really run by lawyers. This is a comfy arrangement for Congress because they don't have to do any of the hard work. They can let these experts, these lawyers who are totally marinated in the ideas of the new left, make the decisions for them, take the credit. Congress can take the credit, and the administrative agencies can take the blame whenever what they do is not popular.
And it's striking to me how back then, this is the 60s, the 70s, all of the terms that are now mainstream, like systemic racism, anti-racism, identity politics, all of this starts in this era in academia, really, but you already see the beginning of all of that back in the 60s, going into the institutions and starting to change them.
That's right. So again, in this lecture, we start seeing the concrete results of all of this theory, all of these troubling ideas coming to the fore. And this is a very important study. It's still hard to listen to, but now we're starting to see it crystallize what has become or what has come from the radical ideology of the left. Now, if you're enjoying this course, or at least if you're learning very important lessons from it, I'd encourage you to take a look at some of the other courses that we offer. Typically, we'll talk about something that's related to the same topic, but because this is such a heavy course and you're doing such intellectual work, I'm going to recommend a course that will help you perhaps get some intellectual and spiritual rest, and that's our course on Dante's Divine Comedy featuring English professor Stephen Smith. This course covers the Divine Comedy, which is the Inferno, Purgatorio, and Paradiso, and Dr. Smith acts as Virgil acts to Dante, walking us through these great works of poetry and helping us see how someone who has found themselves lost in a dark wood can confront their struggles and emerge with a sense of hope and purpose at the end. It's a very beautiful course. Dr. Smith does a great job, and I'd encourage you to take it.
Yeah, and I would encourage people, sometimes, I'm a Protestant, and sometimes you shy away from things like the Divine Comedy because you might think of it as a Roman Catholic work. But I was so wrong, and when I took this course for the first time and went through the Divine Comedy, it's incredible the spiritual insights in the book that help you to look inside and go through that same journey with Dante, reordering your soul and trying to look at things in a new way.
That's right. It's beautiful. It's thoroughly Christian. And as we see ourselves kind of politically in a dark wood, it is a very hopeful course with encouragement for the future. So go online to hillsdale.edu/course. That's hillsdale.edu/course and take the Divine Comedy. Now we turn to Dr. Kevin Slack with Lecture 8, Radicals March Through the Institutions.
In this lecture, we look at the long march through the institutions. That's a phrase that's drawn from the Italian Marxist writer Antonio Gramsci and his prison notebooks from 1929 to 1935. Gramsci had challenged Marxism, orthodox Marxism. Marx had argued that what was real in a political order was really the civil society, the economic relations that underlie it. And what we call politics was just a mere superstructure. It was the ideologies that were used to justify the mode of production and those who owned the mode of production and to justify the role of the disenfranchised laborers. And so Marx wanted to focus on class, not the superstructure of ideas. Gramsci had focused on the superstructure of ideas. He argued that there were certain institutions that peddled these ideologies and that a minority could change society by changing the culture if they could just take over these key institutions in education and in bureaucracy and the like. And so in this lecture, what we'll look at is this long march through the institutions, a phrase, by the way, used by Herbert Marcuse as well, and how the radicals were able to co-opt the different institutions to implement the different liberal laws. First, we'll see how the radicals were able to co-opt funding in the liberals' Great Society. Second, we'll see how the radicals were able to take over key institutions in education and to forward their own ideas. Third, we'll look at how radicals took over the agencies that were created by Congress to implement the 1964 Civil Rights Act, and how they interpreted the law to mean the exact opposite of what it said, and thereby secure their own constituencies of victimized groups. Finally, we'll see how the radicals introduced their own idea of administrative law and how it changed the old liberal scheme of the Big Six regulatory commissions. So first, we see that the liberals had created the Great Society really as a form of graft for their own supporters. They would expand the Democratic constituency with lots of free money. But the radicals used those liberal programs and liberal monies for their own ends. So first we see how the radicals challenged the liberals within the programs of the Great Society itself. One of those was the community action programs. It was designed to increase participation of, and the maximum feasible participation, of minority or disenfranchised groups. The liberals saw this as just adding to their constituency. How could they give free money to new voters? But the radicals wanted to actually empower the poor. And so they began to co-opt those community action programs for their own end. They used community action program monies for all kinds of controversial projects, like Leroy Jones' Black Arts Theater. Leroy Jones would perform Marxist plays on the streets of Harlem. Leroy Jones had said to Negro Digest, quote, "The black artist's role is to engage in the destruction of America as he knows it. His role is to report and reflect so precisely the nature of the society that white men will tremble, curse, and go mad because they will be drenched in the filth of their evil," end quote. The radicals were also able to co-opt money for the National Welfare Rights Organization, or ACORN, and community organizing. Another project that gained attention in the 1960s was the, quote, Hate Whitey Liberation School in Nashville, Tennessee. Lyndon Johnson became disgusted with the media exposure of the radical use of these liberal monies. He even axed a proposal by James Farmer, who had helped to create the Freedom Rides in 1961. This was a proposal for an adult literacy program. He demanded an end to the, quote, kooks and sociologists in the bureaucracy that he himself had created. Secondly, we see how the radicals were able to use the liberals' 1965 Elementary and Secondary Education Act for their own ends. The liberals had wanted to use Title I funding to funnel it into school districts' budgets. And of course, this is how they got a majority of congressmen to sign on board the bill. What school district wants to turn down money? One 1977 study showed that instead of the money going to poor children, rather, more than half of it went to underperforming children. It meant that suburban schools received money just the same as poor schools. The radicals looked at education, and they began to create in the late 1960s and all throughout the 70s a vast literature of what they called hidden curriculum. What it meant was that teachers would now include in their teaching of curriculum new messages, and they would weed out the conservative ones. For example, the hidden curriculum in education, as the liberals had designed it, included, quote, sexist beliefs, attitudes, and values, including, quote, Christian doctrine, heterosexual bias, and speciesism. These were the ideas in the hidden curriculum that radicals needed to challenge so that they could liberate their own students. Paulo Freire's very famous 1970 Education for the Oppressed had argued that education must make, quote, oppression and its causes objects of reflection by the oppressed, end quote, and that teachers could then enlist children, quote, in the struggle against oppression. It meant that you would either take the side of oppression or you would fight against it. And children, elementary school children, must be enlisted in this battle. And so public schools became a battleground where you found spending for education going to liberal programs, school lunch programs, extra money for various projects, but it also went to radical programs. In 1971, Albert Shanker, who was the president of the American Federation of Teachers, had some 73,000 members. In 1971, he testified before Congress and he complained about the money being used for radical purposes. He listed in particular the United Bronx Parents Program, which received $3.2 million in federal funds. And yet he said this only served to, quote, stimulate violence. He said to Congress that the new federal, quote, legislation and court decisions tend to make everything that happens to a student in a school an adversary proceeding, end quote. He gives examples of teachers being pushed down the stairs, of being blamed for stealing their own materials. He said that every time a student is sent to the front office, the administration simply sends those students back to the classroom. And many of these outside radical organizations convinced the students that any act of disobedience was really an act of resistance to oppression against a racist and sexist system. There were other forms of curriculum that were supported by the radicals that had a global character. Globalism as we know it begins in the educational system in the late 60s and into the 70s, although it doesn't take on the importance that it would later on in the 1990s. For example, two scholars, Lee Anderson and James Becker, talked about a, quote, emerging global society. Children would celebrate 1970s Earth Day or Spaceship Earth, and therefore they could transcend the, quote, ethnocentrism so that they would have in mind a, quote, global awareness and how humans beyond the nation state, which now seem to be incapable of solving global or humanist problems, humans would have one identity as citizens of the earth. Racism awareness training, which flourished in the universities, paid very well. The National Education Association, state-level educational associations, the YMCA, and the U.S. Navy all paid for racism awareness training. Radicals began to publish manifestos, whether in the bureaucracy or whether in the National Education Association, to justify a new teaching of systemic racism. One was issued by the U.S. Commission on Civil Rights, entitled Racism in America and How to Combat It. That was written in 1970. It very tellingly had a white figure sitting on top of a black one. And it was how you could educate children, how they were part of a systemically racist system. There was another document by the National Education Association entitled Education and Racism. This was published in 1973. And it proposed, quote, anti-racism activities for children. Children would then put together whiteness collages. They would look for the whiteness is rightness examples in corporate advertising, or they would have activities where students would form themselves into racial castes so they could understand what it felt like. According to this document, quote, all white individuals in our society are racist. Even if a white is totally free from all conscious racial prejudices, he remains a racist, for he receives benefits distributed by a white racist society through its institutions. Our institutional and cultural processes are so arranged as to automatically benefit whites just because they are white. It is essential for whites to recognize that they receive most of these racist benefits automatically, unconsciously, and unintentionally. So the system of identity politics that we hear about so much today was already in place by the late 60s and in the early 70s. By the early 70s, there was a codified dogma of systemic racism, not individual racism, the teaching that all whites were racist. In 1970, Pat Bidall forwarded a new definition of racism as, quote, power plus prejudice. And what that meant is that if you didn't have power in society, you could not be prejudiced. Women could never be sexist against men because women were disempowered. Black people could never be racist because they didn't have power in society. And so the solution, as always, is whites would confess their privilege and become allies in the crusade against racism. Next, we see that radicals took over the agencies that would implement the Civil Rights Act of 1964. The Civil Rights Act had explicitly barred racial preference in hiring, even to rectify past injustices. Here are some of these sections of the Act. The Civil Rights Act, Section 703H, approved impartial hiring tests. What that meant is that businesses could use impartial tests to judge whether a candidate would be good for hire. And there may be disparate outcomes, racial outcomes, depending on which group scored well on the test. That was legitimate, according to the 1964 Civil Rights Act. Section 703J banned affirmative action and all attempts at racial balancing as a form of reverse discrimination. Very famously, Hubert Humphrey stood on the congressional floor and stated that if anyone could find a mandate for racial quotas, he would eat those pages. And of course, there was the famous conservative joke that if we were going by EEOC or OCR interpretations, Hubert Humphrey would have died of indigestion. Section 706G mandated that one must show intent to discriminate, not just statistical proportions. Again, an actual incident of racism committed against a particular individual or group of individuals, but not just the fact that a particular group of individuals was not statistically represented. So how were the radicals able to pull this off when the liberals were so clear in trying to stop reverse racism from taking place? I should point out that the Civil Rights Act of 1964 was a very well-documented act. It's one of the last great examples of this in American history, where it's an immense bill, but you could look at congressional debates and understand the positions taken by legislators for every section of the bill. That's not how it happens today. Now Congress will delegate lawmaking authority in these large pieces of legislation, thousands of pages, to different administrative agencies. As I recall, some 42 provisions were delegated to administrative agencies in the Affordable Care Act so that they could make determinations that congresspersons thought were too controversial to take a stand on the floor itself. And so as the radicals ensconced themselves and took over many of these agencies, the Office of Civil Rights, for example, they could look for help to judges. Judges praised the expertise in equity and diversity of those in these agencies, and they would uphold new standards that controverted the bill itself. For example, the standard of equitable relief, adding a power of injunction. What that means is in the application of non-discrimination law, instead of yanking funding from educational institutions, judges would add a power of injunction so that any of the officers who were charged with the administering the order handed down from the agency failed to do so, they could be charged with contempt of court. It was a way of circumventing the threat of pulling funding from educational institutions. Praising the expertise of the Office of Civil Rights, the Office of Civil Rights would then issue informal guidance to recipients of federal funds that it then expected the courts to uphold. Courts in turn would then defer to the Office of Civil Rights interpretive memos, clarifications, and guidelines, meaning that civil rights law is not really a law in any proper sense of the word. It's a labyrinth of these memos and interpretive guidelines and documents that only experts can decipher. Many of the rules that were passed in the agencies violated the law itself, and they entered law without a congressional debate.
Hillsdale College is a small, Christian, classical liberal arts college that operates independently of government funding, and we want you or your son or daughter to apply. At Hillsdale, students grow in heart and mind by studying timeless truths in a supportive community dedicated to the highest things. Hillsdale College costs significantly less than other nationally ranked private liberal arts colleges and receives regular recognition as a best value, and nearly all students receive financial aid. Our robust core curriculum, vibrant student life, and 8-to-1 student-to-faculty ratio make for an education like no other. For more information or to fill out an application, visit hillsdale.edu/info. That's hillsdale.edu/info.
In 1970, the OCR demanded bilingual education, In 1971, the Supreme Court approved a forced busing scheme, which was in contravention of the law itself. Very telling was the inclusion of affirmative action in government contracts. In 1968, the Office of Federal Contract Compliance set certain standards for companies that contracted with the federal government. This was squashed in Congress by the Comptroller Elmer Statz, and it also violated long-standing bidding processes through Congress. But in one of the ironies of the period, Nixon renewed the Philadelphia Plan or affirmative action in his own administration. In 1969, through Order No. 4, the OFCC extended preferential hiring to all federal contracts, which included about a third of the labor force. Next, we get to the Equal Employment Opportunity Commission, which was there to implement Title VII of the 1964 Civil Rights Act. Congress had intentionally made the EEOC weak. It was called a paper tiger or a toothless tiger. This had to do with individuals who were suing companies claiming to be discriminated against for racial or sexually motivated reasons. Congress had denied broad rulemaking authority to the EEOC and cease and desist powers. But, as with the other agencies, there was a turnover of those on the commission. For example, the placement of Clifford Alexander and many staffers like Timothy Jenkins, who had a much more radical agenda. The EEOC and its staffers began to argue for systemic racism and not individual impact in cases of racism. And the court simply adopted the new standard of systemic racism in the form of, quote, disparate impact in Griggs v. Duke Power Company in 1971, which overturned an objective test that was applied by that company that had a disparate impact on the applicants by group. In the 1972 Equal Opportunity Act, the EEOC was given the power by Congress to prosecute, whereas before it had to recommend prosecution to the DOJ. Large corporations paid out millions of dollars in what amounted to a shakedown. In 1978, agencies passed the 4/5 rule, and that rule was that a company's, quote, selection rate for any race, sex, or ethnic group, which is less than 4/5 of the rate for the group with the highest rate, will generally be regarded as evidence of adverse impact. And so the nation abandoned the legal standard of equal opportunity for equitable relief, or the, quote, full equality of groups. Nathan Glazer, in his review of the Civil Rights Commission's 300-page report in 1970, concluded, quote, there is scarcely a reference to any single case of discrimination by anybody in this enormous report. It uses a new measure, the achievement of full equality of groups. And so group differences were de facto evidence of discrimination, and thus the need for government interventions. The federal courts upheld preferential treatment in voting, union seniority, education, hiring, promotion, and job tests, and the civil rights agencies grew, and radicals became entrenched in them, where they defended their own privilege and they claimed to deliver entitlements to their constituents. To give you an example, blacks were 11% of the population, and yet they were 15% of federal employees. Every civil rights agency grew in personnel and in budget. The EEOC in 1967 had 570 employees. In 1973, it had 1,500 employees. The staff grew from 1966 to 1980 from 314 to 3,746. And over the same period, the budget grew from $2.3 million to $125 million. Even as the EEOC hired fewer whites. In 1966, there were 40% black employees at the EEOC. In 1971, it increased to 49%. And they had to lower standards to do so. They largely ended the, quote, arithmetic and algebraic components of the federal service entrance examination, noted Nathan Glazer. As these agencies delivered entitlements to their constituents, the number of victim groups that could see benefits for themselves grew. To women, Hispanics, Asians, Indians, the elderly, disabled, and homosexuals, and we'll look at a couple of these groups. Concerning sexual education, the EEOC again began conservatively. The commissioners Eileen Hernandez and Richard Graham vacated their seats, seeing them as not being very helpful to women because the EEOC would monitor discrimination on the basis of sex, or so was charged to do. And so they vacated their seats to go help start the National Organization for Women, which would then sue the EEOC on behalf of women. The new appointees in the EEOC took a much more radical view. In 1971, in the revised Order No. 4, quietly extended preferential treatment to women. The 1972 Title IX Education Amendments became a Trojan horse for activism. Birch Bayh had written the amendment and signed it into law, and all he had in mind was women's sports. Nixon, in his signing statement, had only mentioned forced busing. The Title IX Education Amendments prohibited discrimination in federally funded educational programs. And yet the activists at HUE, in Health, Education, and Welfare, applied, quote, adverse impact, the new standard to recruiting, admissions, financial aid, student rules and housing, healthcare, student hiring, curriculum, and women's studies. In 1974, the Office of Education, under the authority of Title IX, set aside $2.7 million in grants for, quote, ethnic heritage studies. Agencies redefined sexual harassment to mean underrepresentation in medical and in law schools. And so what was created was a regulatory morass of graft with myriad well-paid compliance officers at every school and college. When we look at Hispanics as a civil rights group, they had several problems as a group. The first is that they were legally white. In the Ninth Circuit case in 1947, Mendez v. Westminster, the Ninth Circuit ruled that children with Spanish surnames could not be segregated in school. However, under California law, you could still segregate Negroes, Indians, and Mongolians. And so the claim by Hispanic civil rights groups LULAC and La Raza became that Hispanics were not white, they were white other. This was changed in the Cisneros v. Corpus Christi Supreme Court ruling in 1970, where Hispanics were accorded civil rights protection as a minority group. The second problem that Hispanics had was that there were so few of them in number. One of the myths that I've heard quite a bit is that Mexicans didn't cross the border crossed them in the Mexican-American War. One of the problems is that there were only a few thousand Mexicans that were living in the Mexican Federation in those areas of the Southwest. In 1960, the Hispanic population was only 4.7%. And if you looked at Hispanic civil rights as a movement led by Cesar Chavez, it really focused on protecting organized labor, the fruit pickers. Chavez organized the Delano Grape Strike from 1965 to 1970. He founded the United Farm Workers to try to drive up wages for the farm workers so they could receive some of the same protections as unionized laborers. By the mid-1970s, there was a shift from farm worker rights and union wages to illegals as a form of racial power. So we find this odd coalition between Hispanic civil rights groups and large business. Big business wanted cheap laborers, and through James Eastland, who chaired the Immigration Committee in the Senate, they were able to introduce the Texas Proviso, which barred any attempt to enforce employer sanctions or punishments to employers for hiring illegals. And it's through that same Senate that House bills in 1972 and 1973 were squashed. And so the civil rights movement for Hispanics in this alliance with business groups focused on lax enforcement, which encouraged more immigrants. In 1965, the Border Patrol in San Diego picked up 4,000 illegals. In 1976, the same Border Patrol in San Diego picked up 421,000. In 1986, 1 million illegals were apprehended. And thus we see the great irony that civil rights was used to secure entitlements and preferences for millions who would never face discrimination under Jim Crow. In the shift from worker protections to a focus on immigration, civil rights groups like MALDEF or LULAC argued that, quote, to check one's legal status, end quote, was a, quote, act of degradation and oppression. Black civil rights groups, the NAACP and the Urban League, at first opposed increased migration as a challenge to black workers' wages. They would sign on board with increased immigration in a view that it would increase their own power as a civil rights group with the increased number of minorities. The final way we see the influence of the radicals is in a new form of administrative law, which was called command and control. In administrative law, we see a move towards what was called the social regulatory regime in federal agencies and in administrative law. If we compare them to the liberals, remember that the liberals had instituted the Big Six regulatory boards and commissions that were there to protect industries, and where the commissions would work closely with industries. They could set prices, but they also set entry restrictions. They blocked standing for those seeking deregulation, smaller businesses who want to enter the market, and competition increasing waivers. But the radicals argued there was no such thing as public interest. Rather, there were only, quote, distinct interests of various individuals and groups in society. Those groups were civil rights groups, environmentalist groups, consumer protection groups, and worker health and safety groups. And in this new radical formula, elites could mobilize in what was called public interest law. Elites could mobilize and represent unorganized and underrepresented groups. And in the new public interest law, one very famous group was Ralph Nader's Raiders. They could fight for the rights of these constituencies within the agencies themselves, and then friendly courts proved willing to cooperate. In what was called the Due Process Revolution, the court discovered new, quote, property rights in one's right to welfare. Judges extended legal standing to sue to millions of Americans. And so in this new model of administrative law, Congress would respond to each publicized disaster by creating an agency and giving it power to implement broad rules. These agencies were not like the old liberal agencies. They wouldn't decide if a regulation in an adjudication had been broken or not, yes or no. Rather, they would implement detailed decisions. They would set economy-wide standards across entire industries. They became the most expensive forms of regulation that the country had ever seen. Congress benefited from this because it could avoid lengthy hearings. It could claim credit for legislation, and yet it could blame the bureaucracy if the implementation was not popular and say that the problem was the bureaucrats not understanding congressional intention. Some of these new agencies were the Council on Environmental Quality of 1969. The two most important were 1970's Environmental Protection Agency and 1970's Occupational Safety and Health Administration. And added to that were the Consumer Product Safety Administration and the National Highway Traffic Safety Administration. It was not true, as Congress liked to claim, that these were simply matters of expertise. It was true that scientists were expected to make determinations as to occupational safety and health with regard to chemical compounds and substances at parts per million or billion. But one of the things that Americans didn't realize is that most of the employees at these agencies were lawyers at the EPA or at OSHA. The second is that scientists, if they're objective, usually agree on the facts, and they can explain to congresspersons the threat as to the presence of these dangerous compounds. But the scientists themselves have no moral authority. This was a way that Congress could foist the difficult decisions onto the scientists in the agencies and shirk their own responsibilities. And thus we have, at the end of the long march through the institutions, a very top-heavy bureaucratic government with some of the costliest regulations ever introduced in American history. And so we conclude with the creation of two new constituencies, oppressed victim groups and consumers, that would provide the foundation for a new neoliberal consensus that will be the subject of our next lecture.
Thank you for listening to this episode of the Hillsdale College Online Courses podcast. If you want to continue learning about the history of the American left or other topics, please visit hillsdale.edu/course. There you will find 40 free online courses, including Constitution 101, The Real American Founding, American Citizenship and Its Decline with Victor Davis Hanson, and many more. The courses include additional readings, study guides, fully produced videos, and you can chat with your fellow students on a dedicated forum. Upon completing a course, you will also get a certificate of completion. All our courses are free because we believe that these subjects will help you in your pursuit for virtue and happiness, and because a virtuous citizen is the best defense for liberty. So pursue the education necessary for happiness and freedom at hillsdale.edu/course today. That's hillsdale.edu/course. Thanks for listening.